Hi, I'm Brooke Stuntebeck, an attorney here at Triangle Smart Divorce.
And I'm Lauren O'Malley, an attorney at Triangle Smart Divorce, and we are here to talk about prenups across state lines.
Is an out-of-state prenup valid in North Carolina?
It is under the Uniform Premarital Agreement Act. North Carolina has adopted that. So out-of-state contracts are valid, provided they were valid at the time they were entered.
And what would that look like? Signed?
Signed, in writing, signed financial disclosures.
The basic terms of the prenup are outlined.
Yep.
North Carolina recognizes prenups from other states if they were validly signed, if they are part of the UPAA that you mentioned, but also the United States Constitution has a full faith and credit clause that allows valid contracts from other states to be enforced here.
So what happens to a North Carolina prenup if you move to a different state?
If it was a valid prenup here in North Carolina, it's generally valid and enforceable in every state pursuant to the United States Constitution. We have full faith and credit where we accept and validate contracts throughout the nation.
And I think you also need to look at if there's a choice of law provision in the prenup, because I know a lot of the ones I draft say that if there's any dispute about the prenup, North Carolina law controls. So if you do move out of state, just keep that in mind, that North Carolina, if there's a choice of law provision in there, not all of them have them, but some do, where it specifically states North Carolina law will control no matter where you are.
Because marital property laws differ in each state, and so North Carolina is not a community property state, for example. So that might play a role in the division of a marital asset. But if you have that choice of law provision in there and you live in a community property state, it won't apply if you have a North Carolina prenup.